You may remember earlier this week when Mike Purley spoke at your schools in preparation for this program. During his presentation, he discussed several cases from the United States Supreme Court and the impact those cases had on the rights of protesters. I just want to go briefly down the path of how you get to the Supreme Court. So let's start. Supreme Court, of course, is the most important court of the land. District courts like this one are where much of the action really occurs. District courts are the trial courts of a three-level federal court system, and in fact, the drafters of the Constitution themselves gave Congress the power to create these courts. Article 3 of the Constitution states that the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. Now, believe it or not, I was not around when the Constitution was created. Judge Scrutiny was. But if I had been, I would have suggested a different word than inferior. The Western District of New York, which is where you are right now, where you're sitting, is the court where one of the cases that you heard about earlier this week from Mr. Purley began, and that's the Schenck versus Pro-Choice Network of Western New York. Like all district courts, the Western District of New York is made up of district judges like Judge Scrutiny and magistrate judges like myself. Federal district judges are nominated and appointed for life by the President of the United States, subject to confirmation by the Senate. And this way, they cannot be removed merely because they decide a case in a way with which some people may disagree. Magistrate judges, such as myself, are appointed, and we are often said to be on the front lines of litigation, and we oversee potential proceedings in both criminal and civil matters. We issue decisions and recommendations that shape the scope of a case, and sometimes we resolve those disputes from start to finish. District courts are abuzz with activity. Every day, people are arrested. They're brought to this court for arraignment. They're brought to this court for hearings, trials. We have important civil matters that are addressed here, and a civil case simply means that it's not a criminal case. That's oversimplifying it, but those are the two categories that we generally talk about, civil and criminal cases. No one in a civil case is accused of a crime. Instead, the defendants in a civil case are alleged to have harmed a plaintiff in some way, such as here, violating the plaintiff's constitutional right to freedom of speech or freedom of assembly. Now, as I said, I don't think district courts are inferior, but despite best efforts, I also know that they are not infallible. And Congress knew that also. So it developed an appellate system to which litigants who believe the district court erred could appeal. Like the district courts, which represent geographic portions of the country, appellate courts are split into circuits. Each hearing appeals from certain designated locations in the country. Now, in our part of the country, appeals are heard by the Second Circuit Court of Appeals. And that is the court that heard the appeal in the Schenck case you heard about, that Mr. Purley told you about. In fact, the Second Circuit hears cases from all over New York State, Connecticut, and Vermont. In total, there are 13 courts of appeals. Now, decisions from those 13 courts of appeals can be challenged in our highest court, and that is the Supreme Court of the United States. It's located in Washington, D.C. Cases can also reach the Supreme Court from state courts around the country. If a decision of the state's highest court is challenged, that challenge may be heard by the Supreme Court, as in the other cases that Mr. Purley discussed with you this week, such as Terminiello versus the City of Chicago, which began in Chicago City Court. That progressed through the Illinois State Courts of Appeals and was eventually heard by the Supreme Court of the United States. So the Supreme Court consists of 9 justices who hear cases from all over the country. Majority rules on that court. 5 votes is all that is required to dispose of a case. Now, I'm going to let your teachers quiz you on whether the Constitution requires that there be 9 members of the court. Well, the hint is, if 9 are required, we'd be in trouble right now because we have 8. So generally, the court hears only those cases, the court hears only those cases it decides are sufficiently important, and they issue what are called writs of certiorari, which allow these cases to be brought before that court. So that is how cases reach the Supreme Court. They enter through the 3-part federal system: district court here, circuit court or appellate court, and the Supreme Court. Or they arrive through an appeal from the highest state court to the Supreme Court. So thank you for your time. I hope you enjoy your day here at this courthouse. We're very proud of it. I look forward to talking to you at lunch. Until then, I will turn to someone whose word is always final and infallible, Mr. Purley. He's of the law firm of Hurwitz and Fine, and he's very active with our local abota. Mike?
All right.